the Land Court destroyed Maori tenure, Maori communal values, the old Mātauranga, Maori with respect to relationships to the land. All of that was destroyed everywhere in the country. The main mechanism was to hold court hearings in various parts of the country with judges who were people who knew some Maori language. They weren't lawyers, they were mostly surveyors and soldiers and government bureaucrats. The theory of the court hearings was that they should seek to ascertain who were the customary owners of the land. Having ascertained who were the correct customary owner group, the court then created individual titles, originally for a maximum of 10 persons only. So every block of land had to have no more than 10 owners, and they were 10 individual owners. Usually those people who were named as owners were people who were put forward as the rangatira or kaumātua at the time who had acknowledged status in that community. And no one had any doubt about that. But what they found was that having put these people forward as perhaps kaitiaki or trustees for the people as a whole, this was now transformed into individual ownership of that person and that person only. And so whanaungatanga disappears. Well, that was the idea. The court's idea was to undermine whanaungatanga. The court's idea was to get away from having communal values that governed ownership of land and economic production. After the Land Court hearing, you now know that there's just these 10 people that own the land. And so they formed what they called purchase rings. There were groups of people that would get together. There was a group in Hawke's Bay, people called the 12 Apostles, because they were a group of 12 people. But they were a storekeeper, a grog seller, a surveyor, a lawyer, a member of the Hawke's Bay Parliament, a member of the New Zealand Parliament. So you've got 10 people. Now first you pick on the one who you think's the weak link, and you think he would probably like a bit of credit at the local store. So when he next goes along to buy some flour, you say, well, would you like 2 bags of flour rather than 1? Oh, I can't afford to pay for 2. Now, oh, it's all right, we'll put it on the credit, we'll put it on tick. And the system of debt would be created, and the storekeepers would say, oh no, that's fine, get to buy, no problem, give you a bit more credit. And so they create these debts, and then suddenly they stop the credit. Suddenly they say, no, hang on, you've got to pay now, no more flour, no more rum, time to pay, no more brandy. Oh, how do we pay? Well, you've got this land, you own a share in this land, so you'll have to sell it to us, and then we'll cancel the debt. And so those people who had been put there because of their acknowledged position within Maori society are now individual owners who've got debts as individuals that then have to be accounted for. And so that's the way they did it. And then once they've got 2, all right, so maybe they try to get 3 or 4. They then go along to the court and they say, we want to partition this block of land because we now own a quarter of the shares of this land, and so we want a quarter of the land. And so the court says, okay, yes, we'll do a partition. And all of the other owners, the other 6, might say, no, this is our tribal land. You can't do that. You can't take it away. These 4 didn't own it as individuals. They were representatives of the hapu. No, they're individuals. The court said they were individual owners. And so they're entitled to sell. So the court would do that. So then now they've got a quarter of the land. They then hone in on the other 6 and start the process again. And eventually you might find there's perhaps one person who holds out, and you've still got some pockets of Maori land around the country, primarily because some people just refuse to sell. But this caused enormous division within Maori society between the Pupuri whenua and the Tuku whenua factions within each community, those that wanted to hold on to the land and those that were prepared to let it go. And so one of the ways in which the land court system was so effective from the point of view of the settlers is that instead of Maori people being upset with the settlers taking the land from them, they got upset with their relations and had lots of arguments with their relations. So the whole system was intentionally put in place in order to make it easy for the Pākehā settlers to buy. And when I say buy, use these various mechanisms like store debts and so on to encourage the process of alienation. That is the legal word for it. That means selling off the interests that had once been hapu interests. In the bits of land that didn't get sold off and remained in Māori ownership, the question is, what happens when the person that was named as the owner dies? And there was a very early court case about man Takanini in Papakura, and he had been given a crown grant to a very large block of land near Papakura, and he had died, and when he died, his widow and children came along and claimed his interests, but also some kaumātua of the hapu came along and said, no, this is, although that was in the name of this man Takanini, this was not his personal land, it was our hapu land, and that now that he's died, we ought to find out who is the person who's responsible for the hapu now, and that person's name should go in. And the court said, no, we're not interested in recommunalising Maori land. They were quite clear about this. The idea of these crown grants and the land court system is to make it individual. So we will just rule out completely the hapu, and whoever the current kaumātua is of that community, they can't have any say in this land. It's only the successors of this man Takanini. So who are the successors? Well, in English law, there would be one heir. That would be the senior male, the oldest boy, would succeed. And the judge said, that probably wouldn't be acceptable to Maori. They probably wouldn't like it just to go from one to another. So what we'll do is we'll say, no, the wife can't have any say because she's not a direct relation of the man that's died. But each of the children, they can share in the ownership of this land. Now, there was no inquiry as to whether those children were living on the land. There's no inquiry about ahika, in other words. There's no inquiry as to whether these people intended to continue to look after the land for the benefit of the hapu. It was just a simple question, how many children are there? And they were divided up into relative shares. Sometimes the girls got less than the boys, but usually each child would inherit in a portion. So that was the system that was put in place. These days many people think of that as customary succession according to Tikana Māori, but it has to be said it was put in place by Chief Judge Fenton, Francis Dart Fenton, the first Chief Judge of the Land Court, and he just created that rule just out of his head. There was no law involved. He just thought, what's the system that's going to work best to maintain individualisation without getting Māori too upset? And so they thought just having one son inherit might not be acceptable, but having all the children inherit would be acceptable. So that's how it was created. It was just an invention of a judge in the early 1870s. But what needs to be understood, I think, in terms of the historical background, is that this was not a system devised in order to share up Maori land amongst all the many members of the family, or the whānau and hapu, but rather it was meant to make it easy for the individualised shares to be purchased by the Crown, by the government, or by private purchasers.